Hello, everybody. We are back with Avvocato Giulia Crescini from Studio Antartide, so Antartide Law Firm in Rome. And we are in the third video of the series pertaining to Italian citizenship acquisition. Hello, Giulia. How are you?
Hi, Davide. I'm fine. Thank you.
So before diving into today's episode, and very short introduction. We are MultiLex, and we are hosting this series of videos connected to Italian citizenship acquisition. We provide services connected to the Italian bureaucracy. So we help you get the Italian certificates, reconstruct all the lineage, the bloodline, and we also do legalization, apostille services all around Italy. Well, Giulia, would you like to introduce yourself and Antartide Law Firm?
Thank you.
Very short introduction.
We are a law firm in Rome, and we work in immigration field and asylum field and citizenship field. We have cases in front of the civil tribunal and administrative tribunal, and of course we can provide services for people in Italy and abroad. Amazing.
So today's episode, we'll talk about also the recent Constitutional Court judgment decision, and it was published. I mean, the decision was published, I think, a couple of months ago. I think in March, I can remember. And then they published the part very recently where they were justifying the decision, which is, I mean, the meat is there. The reasons why they as we will see with Giulia, they didn't touch the law, so not good news for everybody around the world. But I mean, they also introduced a principle which we'll discuss with Giulia, this activation concept, and we will discuss it with Giulia. So, but let's start from the very beginning. I have my notes, of course, to talk about these complex issues. So let's start from the beginning. What happened last year with this new decree law, this Tajani law, they call it? And what happened with the principle of transmitting the Italian citizenship, you know? And it used to be easy, used to be automatic, yeah, I mean, more or less automatic. What happened, Giulia, with this Decree Law 36 of 2025?
As we talked during the previous call, we know that under the previous law, Italian citizenship was transmitted automatically by bloodline. And in particular, without any generation limit. This was a very important principle in our legal system. In fact, since the beginning, there was no limit of generation, and the only important things was that one of the ascendant was Italian, and the importance was that there was no stop in the bloodline. So as we saw in the past, in the other times, we can say, is that the importance was to provide evidences that our grandfather or our ascendant has never decided to renounce to their citizenship. Of course, after the Decree Law 36 that was issued in 2025, this situation completely changed, because the Italian Parliament, the Italian legislator said that for people that born abroad, it was not possible to apply anymore the bloodline. Of course, there are some exceptions to this principle, but the importance is that this situation, according the fact that a person could have never been in Italy and it has Italian blood because of one of his ascendant was Italian, has not never longer exist.
Yeah. So of course we are talking about now the father bloodline, because there's also an issue with the bloodline through the mother. And we discussed this issue in a previous episode. Please check our playlist on YouTube. We discuss also this very specific issue. So if the bloodline is through the mother before a certain date. So this is something different. We're talking about now people who are born abroad, and of course they have another nationality, because 99% of the cases, when you are born abroad, you acquire automatically the citizenship of the country where you are born. So two of the requirements, two of the criteria to establish whether Article 3 bis, which is the article that was introduced, one of the articles that were introduced by this law decree, is that you were born abroad and you have another nationality. If both criteria are met, then you don't acquire Italian citizenship automatically, and unless, of course, some conditions are met. But anyway, this is not automatic anymore. So, and this was upheld by the Constitutional Court. Anyway, we'll see that later. So, March 2025, something huge happened in the history of Italian citizenships, legislation, laws. Something huge, because, back in the day, not so long ago, we were asked to retrieve documents from the 1888, okay, for great-great-grandfather. And now there is no point anymore, unless, of course, you do a legal action, you do something else. But administratively, so if you want to go via the administrative way, then there is no point anymore to go as further as to your great-grandfather, because now the law is very clear with regards to the degree to which you can go. So your grandparents, that's it. Anyway, there are some exceptions, and we will see the criteria that need to be met. So Article 3 bis, let's have a look. What does that mean in practice? You are born abroad, you are a foreign citizen as well, so you are not automatically Italian, and that's for sure. Based on this law, and this article is quite clear about that. I mean, it is very clear. But there are certain cases where there are exceptions. So there is a list of exceptions. So letter A, B, B, C, and D. Okay. And shall we go through each of them, or shall we focus? Because some of them, A, B, and B, these are I guess more or less, you cannot avail yourself anymore of these these letters, because they pertain to setting an appointment or already having filed a request. But I know you want to talk about this specific thing with regards to the concept of activation of the Constitutional Court. But let's go step by step. I don't want to rush it. So first off, does this apply, all this Article 3 bis, so this is a huge reform, does this apply also to people who were born before March 2025?
Yes, of course. The new law set the fact, the major problem of the law is that it presents, envisage in the Italian law system a very big revolution principle. So the fact that for people that that born abroad, the transmission was not limited, but only with limitation. The problem is that there was no a specific time frame in which people that born before they enter into force of the new law could request the Italian citizenship with the past requirement. So after the law, after the date of 27 of March 2025, all the people was the same. So if you asked the Italian citizenship before that date, you could apply the public administration, and the judge could apply the previous law.
Yeah.
While if you not apply for Italian citizenship before that date, you don't have a time frame of toleration, so a time frame, a frame time in which you could ask for Italian citizenship using the previous law. This is something very strange for our law system, because usually when you introduct a very huge reform that changed the way how people was used to behave or used to interpret the legal system, you always set a time frame in which people could ask, in this case, the Italian citizenship with the previous law. Of course, the Italian government and the Italian parliament explain this decision based on the fact that around the world there are so many people, millions of people that could claim the Italian citizenship with the previous law, that if all these people decide to ask for Italian citizenship in this period of time, this would create a big problem for the consulate. Nevertheless, the problem for the legal system exists because the new law set a very precise date that decide for people which legal system you apply to their case, and the legal system is completely different. And as you said, the new law is applied also for people that born before to 27 of March, but they didn't apply for Italian citizenship before 27 of March. And a lot of people felt that this was illegal and not faithful for their position, because they said that they born Italian, because they had Italian blood since they born, so it doesn't matter when they decide to ask for Italian citizenship. But as we said later, the Constitutional Court said that this decision of the Italian government and the Italian parliament was according to law, so it was not possible to declare unconstitutional. So for now, 27 of March was the deadline, the gong, as we used to call, for require and for ask for Italian citizenship with the previous law.
Yeah. There are only certain exceptions to the fact that whether the scope of application, I mean, whether you fall within the application of the previous law or the current law. And there are certain exceptions. We will discuss today specifically letter C of these exceptions, but let's talk about the first three exceptions very fast, because we want to touch it, because we want to touch them because this might be interesting for those of you who won't avail themselves of a concept introduced by the Constitutional Court in the recent decision, but we will talk about this with Julia. So the three exceptions, please be aware this applies to people who were born abroad, also before the entry into force of these laws, or also before 28th of March 2025, who were born abroad and have another citizenship. so not citizenship, they have another citizenship. Well, in that case, your citizenship is not automatically Italian. You don't have it. So there are certain exceptions. So the first three exceptions, letter A, A bis, and B of this law of Article 3 bis, specifically they pertain to the fact that you requested Italian citizenship before that date, so before the 28th of March, that you requested an appointment, or you had a judgment stating that you were Italian, so a legal decision, a court decision. So how, Giulia, does the Constitutional Court decision in these specific cases has introduced this concept of activation, and how can someone avail himself or herself of this concept in a possible legal action to acquire Italian citizenship?
Yes, thank you for this question, because I think it's a very important topic. We can say that of course the new Italian law indicates and points with the law some specific requirement, specific cases in which you can say that to your case it is possible to apply the previous law. So, for example, if you have an appointment, if the decision, the judge has already decision, and so on. The point is that since the fact that in this moment the Constitutional Court said that is not illegal, the fact that the Italian Parliament decide that this 27th of March is an important date, and before and later the situation is completely different, our work is to try to understand which are the other elements that can link our situation to the previous law. Because, for example, I have a situation that according the new law, I would never become an Italian citizen. But according to the previous law, I could ask and maybe I could obtain the recognition of the Italian citizenship. So it's very important in some cases if I achieve, if I gather, if I collect all the evidence that link my situation to the previous law. So, for example, I think that it's possible to stress the fact that I try to obtain an appointment before of 27 of March, even if I didn't. If, for example, I collect the document and I have the apostille or the legalization with the date that is until 27 of March, all the elements that put my situation before of 27 of March. Of course, this is not the specific requirement of the law. The law requires that I obtain an appointment that the public administration has already set regarding my case, or the judge has already decided. But since the fact that the consequences are so huge, maybe I could try to present a case in front of the judge in which I ask the judge to apply the previous law, because there are evidences that I try to ask the Italian citizenship before that date. And I think that this way of thinking is even more important if we consider that in a lot of cases it's very difficult to obtain an appointment in front of the Italian consulate. So even if the attempt could be used in front of the judge in order to stress the fact that I activate, that I try to open the proceeding. But the problem was up to public administration, was not I mean, it was not a guilty from myself.
Yeah, it was not her fault. It was not your fault.
It was not my fault. And I think that um, this behavior it could be more important also regarding the decision of the Supreme Court, because the Supreme Court just a few days ago decided that I could go for the first time, decide that I could go directly to the judge when the consulate didn't give me the opportunity to ask for Italian citizenship because there are obstacles, for example, long queue or the impossibility to set an appointment. So this means that the judge, and in particular the Supreme Court, have in mind these huge difficulties in obtain an appointment or asking for recognition of Italian citizenship. So from this point of view, I think that these are some elements that we should keep in mind in order to try to apply the previous legislation.
Okay, you touched on several points. I wanna summarize them. The Constitutional Court, which is different from the Supreme Court you have mentioned, so let's make this difference. The Constitutional Court would rule on the fact that a law complies with the constitutional principles, okay, with the fundamental principles of the Italian Constitution. And the Constitutional Court, correct me if I'm wrong, they said, okay, let's have a look at the fact that if you showed that you wanted Italian citizenship, so because you did something, okay, so you weren't guilty, you did something, you were active, you were actively pursuing the Italian citizenship acquisition, that's a behavior which is different from a person who's got like 50 years old and since this new law passed, all of a sudden, decided that, okay, now I want to become Italian. Okay, that's completely different behavior, which is understandable. This different, view, with the different opinion on these two behaviors. And the Supreme Court of Cassazione, this is Corte di Cassazione, this is a different court, which is a very important court in Italy, which established a kind of precedent, even though we don't have the precedent as in different systems, but it's still very important because the other courts, they tend to comply with the decisions of the Supreme Court of Cassazione, Supreme Court di Cassazione. So this is very important because once again, we have a decision saying, okay, if it wasn't your fault, that's very good, because then you can turn to a court and try to convince the court that, look, I've done everything in my, in my possibilities to try to acquire Italian citizenship, and if it wasn't for the consulate or for any other reason which is an obstacle to your action, your activity, then I would have acquired Italian citizenship. So this is the principle, this activation principle. And it is very important because, sometimes you can actually prove that you were doing something with the aim at acquiring Italian citizenship, and you can prove this in a legal action, of course, in court. And this could lead to you having the Italian citizenship recognized through a legal action, of course. This cannot be done via administrative way. So I hope this is it's a very useful piece of information. Please note that we have also published another video regarding the problem with the consulate, with getting an appointment with the consulate. So you can go and watch on our YouTube channel in the playlist or citizenship application playlist, and you can watch the video regarding specifically this issue. What you can do if you can prove that the consulate was not available for an appointment or whatever, didn't reply at all. There is a very long waiting list. So then you can do something 100%. At least you can try. So let's now talk about, if it's okay with you, Julia, let's talk about the Article 3bis letter C. Okay, let's focus on letter C. I'm gonna read it, okay, so that we can specifically talk about it. So this is one of the exceptions. So if this exception applies, you would fall within the scope of the previous legislation. So you can acquire Italian citizenship if first or second degree ascendant, so parent or grandparent, holds or held at the time of his or her death exclusively Italian citizenship. So you have a parent or grandparent who, at the time of your birth, held Italian citizenship. Okay, exclusively, only. Of course, if he or she died before your birth, then you have to check whether at the time of his or her death, he or she had Italian citizenship exclusively. That's the rule. Okay. So, is there anything specific that somebody who seems to fall within this exception needs to know with regard to the specific provision and also the evidence you can bring via the administrative way or before the court to prove that your ascendant was only Italian?
So we can say, as you already told, that this is the big problem and the big themes for this new law, because according the new law, if you are born abroad, you could be never Italian, but there are some exceptions. One of these is, of course, the bloodline. So for if you born abroad, the bloodline still exists, but with the limit of generation. And the limit of the generation is the second level of generation of ascendant. Yeah. So your father, your mother, or your grandfather, or your grandmother.
Yeah.
But the second limitation that is included in the new law is the fact that this ascendant should they need to be only Italian. This is, of course, a very huge problem because the major part of the people, after they set their lives abroad, of course, they obtain another citizenship.
In most cases.
Of course, the situation in the past was completely different because when a Italian man, and in the major part of the cases, the Italian woman that decided to emigrate from Italian abroad in another country, sometimes they died without never acquiring the foreign citizenship. In particular, the Italian woman didn't work, didn't have a social life, working life, and they died only Italian. So there was no problem in a lot of cases to prove that we have a woman that has never became foreign citizenship or a man. Of course, here we are talking about people that are very close to our area, situation, of course, because we are talking about grandfather and grandmother. So in a lot of cases, they have another citizenship. Of course, it is not for sure. It's possible that these people remain Italian, or for example, as we talk about in the last episode, they renounce Italian, or they lost the Italian citizenship by force. So because they have no any other opportunities to work or to live abroad, and so they were forced to become foreign citizen. Or the case of big law that automatically naturalize all these people. Of course, as these two principles that we talked about in the last episode could be applied also in this case. So if our grandfather or our grandmother became American or Brazilian or Argentinian and so on by force, or because or automatically, we could try to explain to the judge that these provisions could be applied also to them.
Because there was force majeure. I mean, they didn't want to renounce the Italian citizenship, so it was like they were never foreigner, they never became foreigner, and they just want to be Italian. So there must be this link. And of course, if you want, correct me if I'm wrong, if you want to avail yourself of this letter C of Article 3 bis, and one of your grandparents was or is only Italian, you still need to have a parent who is at least Italian. So there must be a bloodline, there must be no interruption. Because this, correct me if I'm wrong, this is something that very misleading, because you might say, oh, look, my grandfather was only Italian when I was born, but none of your parents is Italian. It's never been Italian. It's not Italian. How can I avail myself of this letter if there is an interruption in the bloodline?
Of course, this is a very specific question, and depends case by case, and also depend on the foreign law that is applied to the person. Because, for example, if I have only a ius soli law, so my grandfather emigrates in Brazil, and then it remained Italian, and then he had a son that is my father that became a foreign citizen because he born in another territory, the new law could be applied. If my father renounced Italian citizenship and became a US citizen, or he is a US citizen and Italian citizen, of course, I have an interruption. So it completely depends on the specific situation of the case. But the fact that my father or my mother are foreign citizen could be no mean that this provision is not applicable.
Okay.
Applicable.
Okay.
But
Okay.
of course, the question is very difficult, because depends not only on the specific case, but also on the foreign legislation that could be applied to the specific case.
Yeah. I mean, this is it is very hard to prove as well. It could be very hard to prove as well if you go via the administrative way. So if you want to prove to the consulate that one of your ancestors up to the grandparent was only Italian or is only Italian, then you need to submit non-naturalization certificates and certificates like that. So certificates stating that he never became American or he never became Brazilian. And sometimes it's very hard to prove because there is no registration at all. Anyway, this is via the administrative way, this is not the easiest path. This one, the letter C, it's not the easiest one. And of course, through legal action, as we stated, there is more leeway. So there are more chances, you can play with the fact that, there is evidence of the fact that, he or she wanted to stay Italian, didn't want to become foreign citizen. So still, the legal action might be the best option when there is a gray area and you wanna shoot your shot at becoming Italian without setting foot in Italy, of course, because this can be done via proxy to a lawyer, of course. So I'm just reviewing the questions, and yeah, the constitution. We talked about also the Constitutional Court. I mean, in your experience, what are the most difficult cases if you want to avail yourself of this letter C exception? Meaning, what are cases that are more difficult to prove in a court?
Of course, the most difficult cases is when I have a double citizenship and I try to prove that I was forced or I have no other alternative than obtain a foreign citizenship. But of course, I think that it's something to try, specifically when the person want to obtain an Italian citizenship. But I think that these cases will go deep in the next episode, and the person decide not to move for a certain period of time in Italy.
Yeah. Okay. I think we have. I mean, yeah, I said everything. Not everything. Okay, but the gist of it about this specific case, and as you've seen, there are ways to acquire Italian citizenship and to avail yourself of all the legal means to acquire it, or at least try to acquire it. I mean, why not giving it a shot? You can contact us. You can find our contact details in the description of the YouTube video. I thank you once again, Julia, for being always so available to discuss all these issues. We will keep on publishing videos on different issues connected also to this new law. Not only to this new law, also maybe to different ways to acquire citizenship, which are connected to the Italian territory, or maybe you have to stay in Italy, maybe if you have an ancestor. Anyway, we will see. Thank you, Julia.
You're welcome.
Thank you for also always being so comprehensive and to face all the issues from a legal standpoint as a lawyer. That's very important. It's very important to know, because these are issues that are not talked about technically very often. So this is what we try to do in this series of videos on YouTube. Thank you, and we'll see you in the next video.
Thank you. Bye, Davide. Bye-bye.
Bye-bye. Ciao.